This presentation will be focusing on the competence to waive the right to counsel and to represent oneself. This slide goes over the presentation's contents. These consist of definitions that are important to the subject, court cases that are relevant to the subject, and the media source with a closing discussion question. These definitions may be beneficial to know during the presentation. Competence or competency refers to the capacity to perform a given function with a degree of rationality. In simple terms, the ability to carry out a specific task with a certain level of rationality, where the required level varies depending on the task. Waiver is a relinquishment of a right. If the right is of constitutional dimensions, it generally may be waived only under circumstances that are shown to lead to a knowing, intelligent, and voluntary decision. The Sixth Amendment protects the rights of people accused of crimes and guarantees criminal defendants the right to self-representation. Lastly, the standby counsel can offer guidance to the pro se defendant on strategies and explain relevant legal rules. A standby counsel does not violate any rights and can only speak if asked by the defendant or if the defendant is unable to represent themselves. An evaluator assessing the defendant's capacity to proceed would presume that the defendant would not be dismissing their attorney. Therefore, an evaluation of a defendant's competency to waive counsel is typically not included in a competence test, according to Melton et al. It is possible that the decision to go pro se will be made if the defendant has been found competent to proceed. Following the defendant's request to proceed pro se, the clinician should conduct a comprehensive competency to proceed assessment. This involves clarifying to the defendant the disadvantages of proceeding without counsel and evaluating the defendant's comprehension of attorney's responsibilities, such as jury selection, opening and closing arguments, and interrogation. The examinee's motives for wishing to proceed pro se must also be questioned by the evaluator. It is important for the clinicians to be aware of attitudes toward the legal process based on a mental disorder. These include defeatist attitudes, which someone may say, "A lawyer won't help me because I'm guilty." Paranoid ideation, which someone might say, "All lawyers are against me or out to get me." Clearly fantastic objectives, where the defendant believes that a murder victim is not dead, or irrational beliefs, which they think having supernatural powers will prevent the jury from returning a guilty verdict. The defendant's reasoning for wanting to proceed pro se must be rational. If it is clearly irrational, they may be found incompetent. In 1975, Anthony Ferretta was accused of grand theft, which led to the court case Ferretta v. California. The judge granted Ferretta's request to represent himself in court, but removed it after determining that Ferretta did not comprehend legal terminology of the case and had not intelligently waived his right to counsel. According to Ferretta v. California, 422 U.S. 806, there was a 6-3 majority ruling that a defendant cannot be forced to accept representation by counsel against their request. This right to self-representation should be available to all defendants, even though choosing to proceed pro se could be negative. The United States Supreme Judicial Court ruled in this decision that criminal defendants were entitled to self-representation under the Sixth Amendment and should not be denied this right simply because they are unfamiliar with the legal process. The next important court case is McCaskill v. Wiggins in 1984. According to Melton et al., if a defendant successfully waives counsel and proceeds to trial, they cannot be forced to have counsel. The defendant must have control over the case presented to the jury, and the jury must be made aware that the defendant is representing themselves. If a defendant proceeded pro se, a standby counsel may be appointed to help with legal advice or strategies. However, unless the defendant requests it, the standby attorney is not allowed to speak or become engaged. Wiggins requested assistance from the standby attorneys and allowed them to interfere in the proceedings. But when the outcome did not go his way, he filed a habeas corpus petition claiming that the standby counsel had violated his rights under the Sixth Amendment. The petition established whether or not his rights had been violated. As Quimby mentioned in a case brief summary video on YouTube, the petition was dismissed by the district court but was later accepted by the Court of Appeals. This case highlights how important it is for a defendant to handle their own defense under the Sixth Amendment. And if a standby counsel is assigned, they should not interfere with the defendant unless requested to do so. On August 2, 1984, Tom Moran entered the Red Pearl Saloon and shot the bartender and a patron with an automatic pistol 4 times each. Then he took the drawer from the cash register, then left. He went to his ex-wife's apartment 9 days later on August 11th and shot her 5 times. He shot himself in the abdomen and started cutting his wrists after shooting his ex-wife. However, he lived. He confessed to the killings on August 13th, when he was recovering from his self-inflicted injuries in the hospital. On his first court appearance with a designated attorney, he entered a not guilty plea to the first-degree murder counts. Following his not guilty plea, he had 2 court-ordered psychiatric tests and was determined competent to stand trial. However, it was determined that he did suffer from severe depression. In Melton et al., it is said that one of the psychiatrists noticed that he was, quote, in full control of his faculties and the ability to aid counsel, assist in his own defense, recall evidence, and give testimony if called upon to do so. 2.5 months later, Moran wanted to discharge his attorneys and plead guilty. At the time he requested the discharge of his attorneys, he was under the influence of 4 prescription drugs. Keep in mind, proceeding pro se is most likely going to have an adverse effect on achieving a fair trial. The trial judge determines if the waiver is voluntary and knowing, which means the defendant must know the disadvantages and dangers of self-representation. Moran stated he knew what he was doing and waiving his constitutional rights, understood the charges against him, and that he was guilty. The court found that a person who is competent to stand trial is also competent to waive their right to counsel, and that competence to stand trial and competence to enter a guilty plea are similar. At the 1993 sentencing hearing, Moran received a death sentence. However, the majority of the court ruled the competence that is required of a defendant seeking to waive his right to counsel is the competence to waive the right, not the competence to represent himself. Ahmed Edwards was arrested in 2008 when he shot a security guard, an FBI agent, and a bystander after stealing a pair of shoes. After being declared mentally incompetent, Edwards was judged competent after 5 years of psychiatric evaluations. He was then tried for attempted murder. Oyez claims that the jury was unable to make a unanimous decision in the first trial, which led to a hung jury. During the retrial, Edwards requested to represent himself. The judge had granted this decision, however, it was then denied. Melton et al. States that defendants who are competent to stand trial and waive counsel may, however, be required to accept counsel if they, quote, still suffer from severe mental illness to the point where they are not competent to conduct trial proceedings by themselves. In terms of self-representation, this disregarded the Moran case concerning dignity and fairness to the defendant. After being found guilty on all charges, Edwards filed an appeal with the Indiana Supreme Court, arguing that the trial court had violated his Sixth Amendment right to self-representation. Under Edwards, further examination into the defendant's ability to perform trial duties is required if the defendant wishes to proceed to trial without counsel. Without providing any other explanation, the court stated that a person who has the capacity of waiving counsel may be declared incompetent if they are unable to perform basic trial tasks. My media source is based on the case of Bradley Yon, who decided to represent himself in court. There are 2 articles that help understand the case, both of which are short reads in an optional video that is 10 minutes long. He was convicted of robbery, carjacking, sexual assault, and kidnapping a 77-year-old woman. He decided to proceed pro se because he didn't like his public defender, which makes this court case relevant to this topic. You might observe that Yon had no idea what he was doing in court if you choose to view the optional video. He received a 130-year prison sentence. The discussion question I came up with is, do you believe Bradley Yon should have been allowed to represent himself without legal representation based on the news articles that were provided? In this argument, support your response with 1 or more court cases. In other words, do you think Yon should have had a competence evaluation? And if so, why? And these are my references where I gathered my information. Thank you so much.